I'm very excited to start today with our very first session of our very first season of the Queen's Colloquium on Tax Land Policy. And for those who are not familiar with the format, mostly people online, this is integrated. The Colloquium is integrated to our tax policy class. So this means students have already met and discussed the paper last week. And today I'm very excited to have not only an amazing scholar, but also a dear friend of mine, Tarci sio Diniz, to present us his paper. So the structure is going to be, he will present the paper, and then we're going to have a Q&A session. The students enrolled in the class are going to have priority to ask questions. Once they are done, we move to other people in the room that want to ask questions, and then people online as well. And we also have, for each session, we have two co-hosts with me who are students enrolled in the class. So here we have Stephanie and Paige, and they are going to be helping me with introducing the guests and also in managing the Q&A. They're not going to be on screen, but you're going to be hearing their voices there. Okay, so to start us off, Paige, the floor is yours.
Yeah, good morning everyone. I would like to begin with the land acknowledgement. So Queen's University is situated on traditional Anishinaabe and Haudenosaunee territory. To acknowledge this territory is to recognize its longer history, one that predates the establishment of the earliest European colonies. The land holds significant importance for indigenous people who live, migrate, and travel through here. We are grateful to be able to live and learn on these lands. So it is my pleasure to introduce Professor Tarci sio Diniz Magalha, today's guest speaker. Professor Magalha is a distinguished scholar in the field of tax law and policy. He completed his legal studies in Brazil and has held legal research fellowships at law schools across the globe. He is an assistant professor of international tax law at the University of Antwerp in Belgium and has a strong international presence through his research on topics such as international tax governance and corporate taxation. Professor Magalha is recognized for often challenging traditional legal frameworks for those that are more equitable and sustainable. Thank you in advance, Professor Magalha, for taking the time to share your insights and engage in discussion with our class. Please join me in welcoming him.
Thank you, Paige.
Should I? Well, first of all, thank you so much for this warm welcome. This is more than I could expect. And thank you for hosting me. This is my first time in Kingston. I haven't seen much of the city, but what I've seen so far is just gorgeous. I was in this hotel, I opened the window, I arrived yesterday at night, I couldn't see much. So I opened the window, it was right in front of the water, so it was just amazing. I lived in Canada before, I taught at McGill, but I hadn't had a chance to come here, so thank you so much for inviting me. So should I just jump in?
Yeah, go ahead.
All right, so this is a very exciting project to me. You might have heard that there's this global minimum tax being implemented worldwide, something that has been going on for a while. It came out of the OECD Base Erosion Profit Shifting Project, which is a project that was trying to contain tax avoidance, tax competition. It went through a lot of steps to get to this point. But countries at one point agreed to implement this global minimum tax. There's a lot of controversies around them, but here I'm going to focus on a legal controversy surrounding this global minimum tax. Interestingly enough, I am based in Belgium, and this case arose exactly in Belgium. Luckily or unluckily for the petitioners, but so this is an interesting case that arose at the level of the Supreme Court in Belgium, and then has been just referred to the Court of the European Union. Now, just to give you a little bit of a background here, so under European law, there's something called directives, which are implemented at the European level. And oftentimes these directives are going to basically establish a regime that member states within Europe have to implement fully. In this case, the European Union took this global minimum tax idea from the OECD, basically put it in a directive. There was a little bit of a change to adapt it to European law. That change being that the global minimum tax in Europe applies not only to multinationals, but also large domestic groups. There's a threshold of largeness for companies that fall within the regime, but under EU law, they would fall whether they're a multinational operating across borders or mostly domestic. So the directive comes and says, member states, you all have to implement these rules. And then Belgium, as one of the member states, takes this directive and turns it into domestic law. Basically the same. It's 99% a copy of the directive. So then comes this group of business, it's basically a business association where a group of an NGO based in the United States and files this annulment petition at the Supreme Court in Belgium, asking for one of the rules of the global minimum tax to be removed, annulled. Right? Now, you're going to see that because a lot of the issues that are being raised are constitutional issues that also kind of touch on European level law, it is very common for the Supreme Court in Belgium to refer these things first to the European Court of Justice and say, well, this law is a copy of the directive. First assess the directive and see whether the directive violates anything, and then I'll make my decision. So this is at the stage of this debate right now. Now, wait, maybe I have to put this. No? Maybe stop.
Every time.
Yeah. Maybe stop and then, or maybe you have to do something there first. Yeah, let me see. Ah, yeah, perfect. Okay. So this is the billion-dollar question, right? Will the Court of Justice of the European Union kill the global minimum tax? This question is relevant because the global minimum tax is something that comes to solve a challenge. The challenge is that we live in a globalized society, a digitalized society. Multinationals operate across borders. They operate in many jurisdictions. And the fact that we have various jurisdictions where these entities of multinational groups are being located with different rules, different tax systems, creates what we call fragmentation, right? So the fragmentation of the global economy, especially a digitalized one, allows for multinationals to shift profits, to relocate, to establish entities in different places that at the end of the day reduces their amount of tax. Yeah. And the global minimum tax comes saying, well, let's establish a floor of 15% minimum for these large multinational groups. And we're going to get to the specific rules of this regime and how they exactly work. But this is the issue that we're trying to face. And when you exploit this fragmentation, harmonizing is not really realistic, right? Having all countries in the world sit down and write a global treaty on how to tackle multinationals is completely out of question. We've seen this with other projects that have failed recently. So Globe comes and proposes something very unique. It says, well, instead of having this fully harmonized system across the globe that is never going to happen, why don't we adopt a coordinated system of domestic rules? So what Globe is saying, what the OECD is proposing, and that ended up becoming the directive and the law in Belgium and other member states, also Canada, is that countries should adopt basically two rules. There's more, but these are the main mechanisms of Globe. One is the so-called income inclusion rule, or IIR, and the other one is the under-tax profits rule. We're going to see how these rules work and why they're both necessary. So the point that you have to keep in mind here is that the system was designed in a way that these two rules have to be implemented domestically, and the existence of these two rules allows for the regime to achieve its goals. Without any of these two, the regime fails. Right? So the challenge is that at the same time that the regime is something innovative, something new, something you could say creative, at the same time it's very vulnerable because of this mechanism of these rules. Okay, so why does this matter to begin with? So here we're talking about a lot of revenue that is lost through these activities of multinationals operating across the globe and being able to benefit from low tax regimes in different locations and allocate profits to different entities located in low tax jurisdictions. That is something that has been going on for a while, right? For a very long time. The BAPS project has been around for years, for more than a decade, and the understanding is that the issues that the BAPS project, the base erosion profit shifting project, tried to solve were not entirely solved, and that's why we need a minimum tax. We need a floor, right? We need a floor of 15%. You see, there's studies, the studies are not always in agreement, but there's a general understanding from economists and from other institutions that there's a big chunk of money being lost in revenue that is not being taxed, right? Profits that are not being taxed from these multinationals. The United States is the biggest loser, developing countries are not so far behind, and then there's the European Union there as well. But one thing to keep in mind is that the 15% is actually not much high, not very high actually, if we compare the tax rates that exist across the world, especially in developing countries. So developing countries, one of the criticisms of the global minimum tax is that it's actually quite modest to have a 15% floor. Okay, so how does GLOBE work? What are we talking about here? So here you see the two main rules, the income inclusion rule, our IIR, and the under tax profits rule, the UTPR. We're gonna start with the IIR, and we're gonna move to the other one, which is the object of dispute. So the legal case that is now at the European Court of Justice is not really attacking this. It's attacking only the UTPR. Right? Okay, so the income inclusion rule is basically a rule that says, well, if you have a structure, you see there's a lot of acronyms here. We're in love with acronyms in tax law. You just have to get used to them. But basically, you have a ultimate parent entity, right? It's the last one in the chain, though, the one above everything that owns everything. You could have an intermediary parent entity right below, and then there's constituent entities, the other ones, and also a permanent establishment, which is not per se a legal person, although the global minimum tax treats it as a legal person, but let's leave that to the side. So what happens with the IIR is that basically it tells countries from above, so upstream, right, the owners of the chain, to impose a top-up tax on their resident companies if any of the constituent entities below did not pay enough. So in my drawing, I have this constituent entity here is a little red to show that it's being undertaxed. So this company is not paying at least 15%, right? When this happens, the IIR, which is the first rule that applies, will say, well, this country should impose a top-up tax on the UP that compensates what was not taxed down here. So if this company paid 10%, there's also 5% to be paid. So the UPE is going to pay this extra 5%. Yeah? In case the UPE is located in a country that has not implemented the IIR, the global minimum tax says, move on to the next one at the top, the intermediary parent entity. And this one should apply the tax. But the idea is, it's only companies from the top, right? So under taxation is happening at the bottom, top-up taxation to correct it happens at the top. Now this rule looks a lot like CFC rules, control foreign corporation rules, if you have seen these before, but we don't have to get much into this. Let's go to the other side. Now, the under-tax profits rule is something that has created a lot of controversy because it started off as a rule that was called under-tax payment rule, and then they changed it with serious consequences for how the rule applies. But the change came to ensure that the global minimum tax would be made effective. So how does the UTPR work? Well, it works from the bottom, right? So here you have the same structure, UPE at the top, IPE in the middle. You have constituent entities. With the UTPR, you can either have an entity above that is being undertaxed, or a sister company that is being undertaxed. And then these other two will be topped up. So you see that it's very different. It works in a very different way than the IIR because here, this country doesn't have an IIR, so it's not correcting this undertaxation. And then the GLOBE rules will say, well, any other company that is a sister company or a permanent establishment can be called into the scheme to compensate what the other ones didn't tax. Now this is innovative because when we look at this side, there's an ownership structure, right? So we're imposing a tax on someone that is above and owns the one that is being undertaxed. On this side, you could be taxing these two on someone that is above, that is an owner, or even a sister. Yeah. Now, the part of taxing either these two in respect to undertaxation with a sister company is the main issue with UTPR. So here's where the petitioners and some scholars also have criticized this, saying, well, so this company generated profits, they were undertaxed, and then you're demanding that this permanent establishment or this constituent entity compensates with respect to a profit that has no direct relationship with them, right? Now here we could see some relationship, right, going above. So there, I think people were kind of okay. The previous version of the rule would only apply upwards, but because now it applied sideways, people would say, well, this violates a lot of things, right? It's very different. We can't do this. They're sister companies. How can you tax a sister on the income of another sister? There's people making comparisons with humans. How can I be taxed on the income of my brother, right? But this is something I addressed in a paper, right? That we're not really talking about individuals here. We're talking about companies. Companies are artificial. They're creation of the law. This whole structure only exists because of contracts and because the law recognizes them as so. So this is the issue, right? DIR is not being attacked. UTPR is being attacked, and it's being attacked mostly because of this this possibility of taxing a company that is not directly connected to another one. Yeah? Although they belong to the same multinational group. What is the strategy? And this is the interesting part with this case. So the case was filed by a US-based Chamber of Commerce Association based in Wyoming. And then other similar associations across the US also joined the case, asked to intervene, from Arkansas, from California, from Kentucky, from other places. But the interesting thing is, so first of all, they chose Belgium strategically because the Supreme Court in Belgium is known for referring a lot of things to the Court of Justice of the European Union. Right? So once you get to the court and they accept you at the level of the Supreme Court in of Belgium and it's referred to the Court of Justice of the European Union, great. If you get your win there, then game over, right? Then the European Union is going to say, well, this violates whatever you're claiming that is being violated, so no member state will be able to implement the UTPR. Yeah? Now, just one thing that I forgot. The reason why UTPR is necessary is because you have to have rules operating both at the bottom and at the top, from the top and from the bottom. Right? So this one applies first if these countries have the rule. Here, these are going to pay if these countries don't have the rule. So this is how the system locks in countries. This is how it makes it possible for them to want to have those rules, because otherwise, another country is going to come in and take that revenue. Yeah? So why is it that they went for the UTPR only? Well, if you eliminate this possibility, then the regime doesn't exist anymore. The coordination doesn't exist anymore. Right? You just have to find a location where your UPE is based in a country that has no IIR, and then these countries down here will not be able to tax it. Right? Or you base your constituent entity in a country that is low tax, but these countries cannot tax it if you eliminate this rule. Yeah? So we would be left with the income inclusion rule, which is a basic rule that doesn't create this coordination system that Globe is meant to create. Okay, so the strategy was go to Belgium, have this thing go up to the Court of Justice of the European Union, and then let's convince the judges there to strike it down. Once it's struck down, then it's going to be a domino effect, right? All over Europe, over. We're not gonna have the mechanism that we were looking for. And they explicitly asked this in their petition, to refer the case to the Court of Justice of the European Union. One other interesting thing about this case is, and this is something I didn't get into the paper, so the paper, I went straight to the substance, straight to the norms. Why is it I don't think there's violations happening here? But there's a preliminary question that the court had to address, and the preliminary question was whether they even were admissible in court. Now imagine this. We have a US-based association coming to Belgium and saying, well, this law that Belgium implemented, following the directive, is taxing Belgian companies, and that affects the interests that I protect in the United States. And that in itself is already a little bit of a contradiction, because the companies say that they represent multinationals, US multinationals, but they're claiming that the tax is being imposed, which is the case, if it is imposed, it is going to be imposed on a Belgian company that belongs to the multinational, right? So there's a little bit of uncertainty there in terms of how they're even legitimized to be in this case, but the court in Belgium decided that they were. The decision is very short. They didn't explain much why. But in any case, the fact that they went to court, you can imagine a Belgian business association coming to Canada, filing a case at a court here in Canada, Supreme Court in Canada, saying their Canadian law, taxing a Canadian company, affects the interests that they protect back home in Belgium, right? So this is the situation. And I find this also a little bit, in a way, contradictory, because they are claiming to represent the multinational as a whole, but the attack is being done at the level of each entity. And my argument is that we really have to look at the multinational as a whole. But let's get there. So there's three basic claims. They raise a lot of provisions, so this is my classification. I put them into three groups. Claims related to liberty or freedom, market freedoms, claims related to discrimination or equality, and claims related to general principles. Let's go step by step. So claims related to liberty or market freedom. What are they arguing? They're saying, well, when I tax a company in Belgium, in this case, with respect to profits of a sister company somewhere else in the world, yeah, by doing that, I am interfering with the freedom of that company in Belgium to engage in work, because they're paying tax on a profit that they did not create. They might be paying more tax than even their income. Because the tax is imposed to compensate someone else that paid, so it has no relationship with the income, with the economic capacity of the company that is being taxed. Right? And they say, well, if you impose a tax on someone with respect to something completely unrelated, that person, that thing, the legal entity will end up having to pay too much tax, maybe they won't have money, so they're not going to be able to engage in the work they chose to engage, they're not going to be able to conduct their business, they're going to run out of money, they're going to lose their vitality, their economic vitality, they're even maybe going to have to move to another jurisdiction, right? So they don't have the freedom to establish themselves in Belgium anymore. They don't have freedom to provide their services, they're paying too much tax, it's beyond their capacity, and it affects their property also. So the property of that single company in Belgium is going to be taken away because another company of the same group somewhere else in the world didn't pay enough tax. That's the argument. Right? So by taxing entities without regard to their individual profits or economic capacity, the UTPR restricts internal market freedoms and encroaches upon property rights. Now, what is the assumption here? The assumption is that each entity has separate income, separate assets, separate property, right? And we can identify those specifically, even though they belong to the same integrated, controlled, and managed group. And then taxation should be assessed on the basis of each one of them. So here's the contradiction that I feel hasn't been addressed yet in the case, which is when they enter the case, when they requested to enter the case, they said, I'm representing the multinational, right? But when we have to assess any violation, no, it's not the multinational anymore, right? It's each of the single entities. Okay. What is my analysis? So first of all, I think you have to ask yourselves, what kind of freedom are we promoting with this interpretation, right? Freedom from what? And freedom, and whose freedom? Whose freedom are we promoting with this, right? And the freedom from what that I extract from their petition is a freedom from non-interference, right? That in political theory we're going to call freedom as non-interference. So don't interfere with me. You know, I want to do my work. I want to provide my services. I want to be established here in Belgium, doing all my activities, and you're just, you know, slashing a tax on top of me. I didn't do anything, right? You're interfering with my activity. And whose freedom are we talking about here, right? The freedom of the multinational group to operate in any way they want. Right? So my response, and this I extract from literature on EU law and some cases, is that, in fact, we don't have this idea of freedom as full non-interference, right? Non-interference from taxation, non-interference from regulation. Freedom should be understood as non-domination. Yeah? So if you look, for example, at the provision that talks about business freedom under EU law, it's going to say, well, you have the freedom to conduct your business in accordance with union law and national laws and practices. It's not freedom from law. It's not freedom from tax. It's not freedom from regulation, right? It's freedom within a regulated and legally established order. And this legally established order did not have a directive before, but now it does. Right? So this is established order that we have freedom to conduct our business in. When it comes to property, if you go, so the provision under EU law that talks about property takes inspiration from the European Convention on Human Rights. And that convention says, well, property recognizes the payment of taxes. It's not property without taxes, right? What we have as property is the after-tax property, or the after-tax income. So that's my response here. The other claim is the claims of equality or the claims of discrimination. So basically they're citing two provisions of the EU Charter of Fundamental Rights, equality before the law, non-discrimination. And basically what they're saying here is, if you tax a company in Belgium that maybe doesn't have enough money because someone else in the chain didn't pay enough, this company is being discriminated in comparison with another company that maybe also have a little bit of money, but is not being part of a multinational group. Yeah? Because if you're not part of a multinational group, then there's no top-up tax on you. They're saying, well, look, you have to look at these two little companies. Maybe they don't have enough money. You're discriminating them. The one belongs to a multinational group and is paying a top-up tax. The other one doesn't belong and is not paying a top-up tax, but they have the same income. They have the same ability to pay. Yeah? That's the basic argument. Again, the assumption, and this for me is what cuts across the entire petition. The assumption is, do not look at the group, look at the entity. Do not look at the group, look at the entity. So each entity should be assessed individually and compared, each one of them, to others with similar profit. Forget that it belongs to a very profitable and very successful multinational group. Forget about that. It's just the small little company in Belgium that is being overtaxed. So what is my response? Well, so first of all, I think there are two questions. So the first question is, can group membership justify a discriminatory treatment? And what is it that we use to compare? Like, what is the comparator that we should be using? My answer is that, first of all, group membership is not a fundamental right. It's not something to be protected. It's not a human right. It's nowhere to be found as a human or fundamental right to be protected. So establishing a regime that considers that a company belonging to a multinational group has to pay a top-up tax because it belongs to a multinational group in itself, for me, is not a violation of the law. And then the ability to pay that we have to consider here is the entire group, not a single one. The global regime came to ensure that large multinational companies pay a minimum 15% of tax, right? That's the logic of the regime. So responding to that logic by saying, well, but look at the small company, it's just speaking in different terms. It's talking another language. Okay. Finally, principles. There's two principles that they invoke. One is legal certainty. This is the part of the petition that I find the least convincing. So the legal certainty say, well, you know, if you impose a top-up tax on a company in Belgium with respect to profits somewhere else, that little poor company doesn't know where they're going to have to pay. They're, you know, embedded in uncertainty. They don't know how to conduct their businesses. And then they say, well, it's also extraterritorial. It's extraterritorial because you're taxing a company here in Belgium, but the profit came from somewhere else. So you're reaching outside the territory of Belgium. Again, assumption, global profits can be split precisely between entities. Each has their own profit, each has their own assets, and they can be assigned to each of those companies. So the profit that you're trying to reach is fully outside your jurisdiction. So that's the assumption. Yeah. What is my response? Well, first on legal certainty, the global regime is a rule-based regime. Right? It's not a standard-based regime. So usually there's a distinction between rule and standard. Standard is kind of more abstract and more difficult to apply. A rule is more defined. It's very detailed. There's a lot of guidance, and it only applies to large multinationals that have all the ability to handle the complex. So I don't see uncertainty there. Also, to say that a small company, in this case in Belgium, doesn't know what kind of tax it's going to pay because someone else in the chain didn't pay enough. Well, they're part of multinational groups, so the UPE, the ultimate parent entity, knows everything that is happening. It controls the entire group. It knows where its entities are. It knows if they're going to be undertaxed or not undertaxed, right? So certainty for me is not really an issue here. When it comes to territoriality, well, so the tax is imposed by Belgium on a Belgian resident, right? The fact that the calculation of the profit refers to some activity that happened outside, to me, doesn't violate principle of territoriality. I mean, we're used to doing this in tax, right? We impose tax on our residents with respect to profits, activities happening somewhere else. The only reason that we can sustain the claim that those profits are separate is that if we adopt a very strict separability of companies. One is one, the other is the other. But once we overcome this, and the paper tries to show that separability is not a legal principle, it's not a hard law principle, I don't see why this would be a problem. If you look at things like CFC rule, guilty in the United States, alternative minimum tax, the income inclusion rule, they're all taxing profits outside the territory. Right? The territoriality in tax is not as strict as in other areas. And then, on jurisdiction, I would even claim, if you live in a digitalized world, and these are the companies that are being taxed, what is the territory? When does the territory of the state stops, and when does the other one begin? I think that question could have been raised even before the digital economy, but I think with the digital economy, it's more obvious, right? Profit allocation within multinational groups is not science. It is not based on objectivity. It's based on design, rules, contracts, and conventions. Right? The only reason I can say that this income belongs here and not there within a multinational group is because I have rules, profit allocation rules, that would say, well, consider these factors or that factors. But that in itself is not a manifestation of nature or reality or something objective that is beyond law. So profit allocation has always been conventional. When we look at the global minimum tax, what Globe is trying to do is look at the reality of multinationals and say, well, this is an integrated group of companies, and the way they allocate profit between them can never be really verified if it was correctly done. Right? That's the challenge of the rules that we have of transfer pricing, profit allocation. That's why we end up with companies paying so little, because it's really difficult to be able to say that this profit really belongs here, really belongs there. Okay, so that's my response. And then, everything for me comes down to this question. I think the whole petition is based on this assumption. The assumption is companies have to be treated separately. There's some form of separability as a principle, legal personality as a principle. We have to respect it to the max. And to some extent, I don't blame them for raising this, because there is, that assumption is sometimes commonly found in literature, right? It's something that we tend to assume. We think, well, if we have two different companies, have one with one personality, the other one with another personality, why is it that we're just erasing those things? Yeah. But a big chunk of my paper is to try to show that if we go to corporate law, both law decisions, statutes around the world, literature, there's a strong literature in comparative corporate law, it would show that pass-through regimes, so basically erasing this distinction between company A and company B that belong to a group, it's a common practice. Countries will do that. It's not limitless, obviously, but they will do that in order to achieve certain goals. So pass-through approaches in corporate law go far beyond what you might have heard in business association or a course like this, veil piercing. Have you heard this before? Veil piercing, right? The judge pierces the veil and then gets to the shareholders, right? Gets to the assets. Erases the difference between the shareholder and the company, or even the other way around. So there's a strong literature that would say, well, this is one example of erasing these boundaries. And this is not really what we're talking about here with Globe. Veil piercing is usually done by judges in a concrete case, so it tends to be more restrictive, obviously, because we don't want judges to be erasing the distinction between companies anytime they want, right? There has to be something happening. Usually it's abuse. But it's very different when the regime itself comes with a different approach and says, well, look, we are not going to treat multinational companies as we treated them for decades, because look where it got us. It got us to a place where we cannot really tax them. So we have to look at them as a whole. And here are some examples in corporate law where this distinction between companies is kind of erased, double derivative suits, inspection rights when the law says that shareholders can go, or the parent can go into the subsidiary and inspect their documents, right? If the distinction was so rigid, it would say, no, it's a different company, you can't, right? Consolidated accounting, we put together income and profits and everything in the booking of the companies all together. Mandatory by bid rules, etc. If you go to tax law, I think this is even more obvious. You might have heard this before. Tax law tends to follow private law, corporate law, these other areas, but it doesn't have to, right? And this becomes very obvious when we see, if you look at the Income Tax Act here in Canada, you're going to see a bunch of deeming rules, yeah? How do you define a resident in Canada? You're going to find a bunch of deeming rules in the Income Tax Act saying, well, in this situation, we're going to deem you to be a resident, right? So even if maybe you're not falling to the strict category, but we're going to deem you anyway. When we use joint liability, like several liability, right? We take a family with children and the mother and the father and the father and the father and the mother, and we put them together and say, well, you have to pay tax for this other person. Joint filing. This doesn't really happen much here, but in the US, it's possible to file as a couple, right? Well, a couple is two different people, two individuals. They have their own income. Why are we mixing them? We're mixing them because the law said so. We decided to mix those personalities. Consolidation regimes, the same. We take a group of companies and say, well, you can file one tax return together. Put all your income, all your losses together, calculate and pay your tax. Group taxation, formulary apportionment exists here in Canada, exists in the United States, exists in Switzerland, right? You kind of look at the group as a whole and try to allocate profits through a formula. And many legal fictions. If you take international tax course, you're going to see there's this thing that we call a permanent establishment. It's a legal fiction. It's not a separate legal person, but for purposes of tax treaties and taxation, we're going to treat it as a separate legal person. Or even the expression that you might see all the time, for tax purposes. Right? That expression itself says, for taxation, we're going to treat something that you might think that should be treated in a certain way differently. Yeah? Maybe different from other areas of the law, maybe even different from the same Income Tax Act. There's a provision in Income Tax Act that would say, well, this would happen this way, but here, in this situation, for purposes of this provision, it's going to be treated that way. So I don't see tax law being prohibited in any way from adjusting these boundaries. And if you go to international law, I also fail to see any hard law principle. If you look at general international law, corporate separability is recognized as state-rented. There's a decision that I cite in my paper from the International Court of Justice that says there's no international law regulating corporations, regulating personality, regulating how we treat abstract entities. Those things are going to be found in domestic law and maybe in investment treaties. So those are things that countries will, and lawmakers will decide on their own, right? There's nothing above states saying you have to respect separability of companies. The income of X is income of X, income of B is income of Y is income of Y. Investment law. If you go to investment law, you even see that the approach there is explicitly more different. Because investment law tends to try to protect investors, it's very common to erase these distinctions in order to protect investment, to protect investors, so that you cannot interpose a company and then harm the interest of the investor and say, oh no, but this is a separate company. So in investment law, it's even more common to find this economic identity. If you go to human rights, and this is the most fascinating part that I think, you might know that sometimes corporations claim human rights. Yeah? You might have seen this in the United States when they claim they have freedom of speech, or that they have freedom of religion, right? Which to me is something fascinating, because the word human in a sentence has to have some meaning, right? Like, we're talking about something there. But I know there's reasons for that. It's not completely nonsense, but corporations will sometimes claim human rights. But if you look at regimes around the world, the regimes in America, the Convention on Human Rights, in the Inter-American Convention on Human Rights, will exclude corporations from human rights explicitly. It says natural persons have human rights. Africa is the same. It's also excluded. In Europe, it's complicated, and this is the catch where they're trying to make a case here. So in Europe, the European Convention of Human Rights will say that natural and legal persons have some rights, right? But the thing is, there's only one right that the expression legal person appears, natural and legal. It's the right to property. All the other rights, the convention is not clear. Sometimes it doesn't really say who, or it says everyone. So here there's a controversy in the literature, but also in the European Court of Human Rights, where the court sometimes extends some rights to corporations, interpreting everyone to mean legal and natural. But anyway, if we read these conventions, you're not going to find a right to strict separability, a right to personality, a right to have everything treated separately. So there I also fail to see reasons why there would be any form of hard law that could be invoked against Globe. And once we get this out of the way, the idea that companies have to be always treated separately, that we're dealing with a new regime, then I think all those claims that they raised kind of fall apart. Okay, so what is at stake now? This is the stage where this is at the moment. So the case has been referred to a Court of Justice of the European Union. From what I heard, it might take a year to be decided. That's why I want this paper out as much as possible. If the European Court of Justice finds that the UTPR indeed violates any of those rights and takes it out of the directive, Globe is over. The global minimum tax is over. Right? And I think that's a very clear legal strategy, right? Like a smart strategy for lawyers to go after the rule that is a little bit more controversial, but that is essential for the regime. If you take it out, it's over. If the Court of Justice says no, which I believe it should say no, then we open up possibilities for moving forward with other projects, other global projects. So, I'm curious about your opinions on this. The verdict is still to be decided, and thank you so much.